Today's webinar is titled Privacy, What Canadian Businesses Need to Know to be GDPR Compliant. This is a topic which is very top of mind for a lot of our clients, and a lot of questions do come through the door in terms of whether it applies to them and what they should be doing, if they should be doing anything to be compliant with this regulation. So what we thought would be helpful is basically divide up today's presentation into two parts. The first part, I will be providing an overview of the legal requirements under GDPR and what it means for businesses outside of the European Union. And then my colleague, Colin McClure from Appnovation, will be talking about some of the technical requirements to be compliant with GDPR. Before we get started, what I'd like to do is maybe just do a couple of quick introductions for Colin in particular. We at Miller Thomson are delighted to be partnering with Appnovation, which is a global digital solutions and managed services provider focused on building high-performing, secure digital experiences while providing a full range of creative capabilities to their customers. Colin, who is located in Europe, is one of Appnovation's top solution architects who began his career by doing a bachelor's degree in commerce, specializing in information systems management. He has also worked on a wide variety of projects across varying types of technologies, both open and closed, and in many sectors. He takes great pride in being a conduit between technical and business domains. Having started and run his own business, he has a unique perspective on projects and a wealth of knowledge to apply intelligent and programmatic solutions. So with that, and without any further delay, we'll get started. We have a busy 1 hour ahead of us, and just a couple of housekeeping items before we get started. Today's webinar is going to be recorded and will be made available to all of the attendees who had RSVP'd and are attending this event. Those who weren't able to make it will also be receiving an email with not only a recording, but also a copy of our presentations, as well as an article that talks about GDPR and how it applies to Canadian businesses. So today's agenda, as I described, is basically going to be divided up into two parts. The first one, I will be providing an overview of GDPR and some of the requirements under that regulation. And then I'll be passing it over to Colin McClure, who will be talking about some of the technical aspects of it in terms of compliance. So before we get started, I thought it'd be helpful because the GDPR, for our audience who are not familiar with it, is a European regulation, and often we get the question as a Canadian business, why would this apply to me, if at all? We'll get into that in just a moment as to why it applies, but before we do so, there's a difference in terminology when it comes to GDPR. So over here on this slide, I've included a couple of common terms which are unique to GDPR, not commonly found in our Canadian privacy legislation. And I want to draw your attention to the first two, which is a data controller and a data processor. In Canada, if you look at, for example, PIPEDA, which is our privacy legislation at the federal level for private organizations, we don't have the clear distinction between a controller and a processor. In some cases, it could be the same entity. In other instances, they could be two different entities. So think, for example, of an organization that's collecting information about customers and then passing that along to a vendor who is going to be processing that data for either emailing or other purposes of storage or analytics or otherwise. In that case, you can see there's a division between who is a controller, meaning the entity that is collecting that personal information, and who is the processor, entity that is actually processing that data on behalf of the controller. In Canada, we often use the term an individual in PIPEDA or any other privacy legislation. In Europe, individuals are identified as data subjects of that legislation. In Canada, we often talk about a privacy officer. In Europe, it's slightly different. It's a DPO or a data protection officer. And lastly, and I'll be talking about this in one of my latter slides, is supervisory authority. As you know, in Europe, you have supranational entities and you also have regional and national entities. In the case of GDPR, you will have to opt for a supervisory authority, which is a national data protection authority within the jurisdiction or a member state. So before we get into GDPR and what it is and what it does, I thought it would be helpful just to give you a bit of an overview in terms of its history. And it does start back almost 20 some odd years ago when the European Union adopted the European Data Protection Directive. It was a piece of guidance that was provided, which was binding on the member states, and provided information in terms of what organizations need to do when it comes to privacy and human rights law related to privacy. At various stages between 95 and really starting in 2010 onwards, there was a lot of discussion that that piece of guidance needed to be updated. The directive needed to have a bit more teeth, needed to be a bit more in tune with new digital technologies, especially with the rise of electronic commerce and organizations transferring traditional data into the digital format. And what ended up happening was in 2014, the European Parliament adopted GDPR, which was a piece of legislation, if you wish, that was extremely controversial in many ways. It imposed significant obligations and responsibilities on those data processors and data controllers that I talked about a bit earlier. What was interesting was that the European Parliament, despite having multiple discussions and multiple roundtables with stakeholders, decided to go ahead with the legislation in an overwhelmingly favorable manner, where 621 votes went in favor of it, 10 against, and only 22 abstention, which means that it had the full backing of the member states. In 2016, that was passed as being coming into effective for 2018. It's going to be actually coming into force specifically, I believe, on May 25th, 2018, so roughly about 8 or 9 months from now. The one thing I will mention about GDPR is it shouldn't be viewed in isolation as just a European initiative. The reason it got traction so quickly between 2010 until today, and subsequently when it'll come into force in 2018, is because it's very much consistent with what the approach has been in the United States and in other jurisdictions such as Australia and soon to be Canada. So what we're seeing more and more is that the requirements that were outlined in GDPR are going to be more and more in line with what's accepted and in place already, certainly in the United States, but also soon with Canada's data breach notifications coming in with Canada and other jurisdictions as well. So there is a clear convergence when it comes to data protection requirements globally. Some will argue that GDPR is probably the most onerous one and setting the bar very, very high for other jurisdictions to follow. Certainly, it does impose significant requirements on organizations, but what it does emphasize is the fact that it is a movement in towards that direction of protecting data in a more clear manner. So for the purposes of today's webinar, what I wanted to do was really focus on a couple of key aspects of GDPR, which are outlined here. And I'll start with the first one in just a minute, but global reach and how it actually applies to Canadian organizations or organizations that are located outside of Europe. I'm going to talk very briefly about some of the tough sanctions and the financial penalties associated with it. They also have a very specific data breach notification requirements, which are quite aggressive. There's guidance in terms of how data should be governed generally. There's also a requirement for privacy by design. So this is where organizations that are implementing, for example, a new application or a new product that's going to be collecting personal information, they will need to incorporate privacy by design and not just be an afterthought to make sure that they're complying with privacy requirements. There's also significant requirements when it comes to individual rights to personal data. And also there's enhanced requirements for supply chains. And I can't emphasize that enough. Certainly it's present in GDPR, but it's also present in other jurisdictions. A lot of the questions we get are related to the fact we're an organization that deals a lot with third parties. So we have a complex supply chain. And as a result, what should we have in our contracts to make sure that the data we're providing to our vendors are protected appropriately, not only based on Canadian standards, but also with this incoming regulation in Europe, because it will have significant fines to it. Similarly, we also are getting questions that we are the recipient, we're a vendor to another entity. What do we need to do to be compliant, but certainly what is acceptable as a bare minimum standard that we can adhere to? So I want to talk about global reach because that's the biggest question we get. And as most of you would be familiar, when a legislation is passed in a given jurisdiction, it typically only applies to that jurisdiction. What we're seeing now, and GDPR is not the only one. For those of you who are familiar with Canadian legislation, especially on the anti-spam side, CASL, there is now a trend more and more internationally to have extraterritorial application to certain types of laws. So for example, CASL, which is a anti-spam law in Canada, if a American or a European entity is sending emails to a Canadian resident and are non-compliant with CASL requirements, theoretically they could be caught by CASL and be fined and enforcement action taken against them. Similarly, GDPR has the same approach. In the United States, you have other laws, for example, the Defend Trade Secrets Act, which also has extraterritorial application. So the takeaway with GDPR is it is a trend towards extraterritorial application. And that's consistent. It's consistent with the fact that technology is changing, digital assets are being collected, and then they're being transferred across borders, not just limited to Europe, but to other jurisdictions as well. So when it comes to GDPR, as a general rule, they certainly do apply to organizations that are established in Europe. So these are organizations that have a brick and mortar location, and for them, the issue of jurisdiction is not a major concern. For organizations such as Canadian companies that may be doing business in Europe, either with a brick and mortar location or without, you'll see here on the second bullet that it also applies to those organizations that are located outside of the EU, so long as they process personal data, so that's the data that they're collecting, which is personally identifiable, about EU data subjects, and it has to be in connection to one of the two following: either offering goods or services, payment is not typically required, and a monitoring of their behavior within the EU. And I just want to spend a couple of minutes on the offering of goods and services. Simply having a website which is accessible to a European data subject does not automatically put a company within the reach of GDPR. What you need to have is an intent to be able to target and offer those services or those goods to EU data subjects. So for example, if an organization is buying through a search engine targeted ads to bring them to certain websites, or if on their website they're providing them a list of toll-free numbers that they can call from Europe, let's say into another jurisdiction, or if they have something which has been uniquely crafted for EU data subjects to be able to get that good or that service, that would typically qualify as a direction of offering goods or services. And in that case, that Canadian organization would be caught, in fact, under the GDPR. The second bullet on the monitoring piece is a bit more tricky, and it typically involves companies that actually collect a very large amount of information. So think of large organizations that are collecting a tremendous amount of information. You can think of your Googles of the world that do a lot of analytics in terms of behavior within the EU membership. And so those would be organizations that would typically be caught as well. What is unclear based on the language of the GDPR is whether this would qualify or capture a business-to-business relationship. The common thinking is it probably would not, although there is some debate on that issue as well. So the next big issue that's unique to GDPR is the data breach notification. So for most Canadian organizations, we have our privacy regime here. If there is a breach with the upcoming mandatory breach notification requirements to PIPEDA, we will have an obligation, or those organizations will have an obligation to not only notify the regulator, but also to notify the affected individuals. And although it is supposed to be as quickly as possible, there's no prescribed period of time in which you need to notify either the regulator or the individual. Under the GDPR, that's a bit different. What we see here is, certainly a processor. So these are the parties that are actually processing the information, and the controller must notify the controller without undue delay. And the controller is the entity that's collecting that information. The controller, in turn, must report to the regulator within 72 hours. That's a very short timeline. So think of learning of an incident or a breach within the organization, and then having 72 hours to report that. So you need to have a prescribed format in which you're going to be reporting that to the regulator, and it requires you to have basic information. So conducting a basic investigation internally, being able to provide, for example, a description of what happened, what type of information was affected, how many accounts may have been compromised, and what remedial action is being taken to ensure that the risk level for the affected individuals is mitigated. And so 72 hours is a very, very short timeline to inform the regulators. And on top of that, if there is reason to believe that the individuals will be affected, you need to inform those data subjects relatively quickly afterwards as well. The other requirement, which is also very similar to what we're going to be seeing under PIPEDA, will require controllers to maintain an internal breach registry. So this is your internal log that will keep a register of every single incident that has occurred within the organization that would meet a definition of a breach. And non-compliance costs are quite significant. They can vary, and my understanding is at the early stages it will be on a sliding scale. So they certainly can go up to 10 million euros, but they probably won't hit somebody with a $10 million euro fine from the get-go. There will be a sliding scale in terms of gravity and other factors that are going to be considered in terms of issuing those penalties. Or it could be a fine of 2% of global revenues, which is also quite significant. So for each one of these different items, I thought it would be helpful to provide you a list of recommended next steps for organizations. And obviously, this will vary from one organization to another depending on how ready they are, how much time they may have invested already. And one of the common myths that exists in the marketplace is if an organization is theoretically caught under GDPR, that because they're complying with PIPEDA in Canada, they would automatically be sufficiently compliant with GDPR. And on that point, I can assure you, having seen some of the statements coming out from the enforcement agencies in Europe, that that would not be the case. The expectation is that, you know, if you're complying with PIPEDA in your own jurisdiction, great. But the moment you're collecting information about EU data subjects, you need to comply with the specific requirements of GDPR. So on this slide, you'll see a couple of items, and this is by no means an exhaustive list. And I'll go through them very quickly, but these are steps that organizations should definitely take and paper to have within their organization. I'll explain why that is important towards the end of the slides, because you want to have a record that you can produce before the regulator, showing them that you have actually put some thought, resources, and effort to comply with the GDPR requirements. So the first thing I would recommend is develop and have an internal breach notification system and incident response plan. Most organizations will already have this, but you may want to pull that out and make sure that it complies with the specific requirements of GDPR. If that means taking your global plan and indicating that you will have specific requirements if you have a data controller or if you're acting as a data processor, that you will be able to comply within those timelines that I mentioned earlier, that will be a very good first step. To the extent that it's required, you may want to consider conducting tests and reviewing your processes. You want to work with your IT team to make sure that they've implemented appropriate measures to render the data basically useless for any hackers or cyber criminals if they were to get their hands on it. So this could mean using encryption or any other kind of security safeguard to make sure that even if the data got out of your network for whatever reason, it's not going to be a problem. The hackers will not be able to monetize it because the information would be absolutely useless because they can't access it. You may want to also take a look at your insurance policies in the case of a breach. And this is really, really important. I'm a big fan of cyber insurance coverage generally. And the reason for that is it does provide useful resources in the case of a breach. So for example, it'll help you get a breach coach in place to make sure you can assure privilege, and that you can have an investigation done in a manner that will be compliant with any litigation requirements. But it also helps you get additional experts and resources that you would need. For example, a PR firm, or if you need to set up a call center to be able to field questions from the individuals. What you want to do in that case, if you already have insurance that deals with a cyber incident, you may want to have a conversation with your broker, if you haven't had it already, to talk about specifically what happens if there's a GDPR type breach. And would this insurance coverage provide you any kind of assurance that they would actually step in and help you out in those early moments after discovering that incident? And lastly, one of the things you want to focus on, again, goes back to the supply chain management. is to update your MSA, your data protection clauses, and tender documents to the extent that you're dealing with third parties. You want to make sure that you require suppliers to proactively notify you of any breaches, and that's going back to the previous few slides where data processors must inform you as quickly as possible. And you also want to have a clause in there that puts an emphasis on the duty to cooperate between parties. So the next requirement under GDPR is really related to data governance. And I won't spend too much time on it, but it is an important component of the GDPR. It requires organizations to implement measures that will reduce the risk of breaching GDPR. You want to have protocols and policies in place that have proactively thought about the requirements under GDPR, and that you can actually show to the regulator, if you ever had to, that you had actually implemented those steps. Next, you also want to look at measures such as privacy by design, which I talked about a bit earlier. You want to look at whether you can conduct privacy impact assessments. For those of you who are not familiar with it, for example, if you're rolling out a new web application or an application which is going to be available, let's say in the iStore or via Google Play, you want to make sure that you've done a privacy impact assessment. And what that does is it assesses whether your product is collecting personally identifiable information and what the risks are associated with it. Are there any material gaps that you need to think about? And it's a very clear matrix that you can go down and really check off the boxes to make sure that you've actually taken the steps to comply from a privacy standpoint. You want to have a process in place for audits, protocol and policies, which I talked about, which need to be reviewed. And in some cases, depending on the scope and the size of the organization, you may have a legal requirement to appoint a data protection officer, similar to what we have in Canada, which is a privacy officer, but this individual would have specific responsibilities and obligations under GDPR. So with that, if you look at your to-do list, you want to have a couple things in place relatively quickly. You want to designate a person who's going to be responsible for data protection within the organization. It could be the same individual who's dealing with privacy within the organization. It could be your CIO, your CISO, but you want them to have that responsibility. You want to designate them in a formal manner, and you want to have them understand that they are responsible for GDPR compliance. Second, you want to ensure a full compliance program is documented, and quite frankly, it's more of a defensive approach. The reason you want it to be documented is you are most likely going to be going through an incident or dealing with the regulator at some point in time. The moment the regulator approaches you, before they issue any fines or any penalties, they will have a dialogue with the organization, and they will ask the organization, have you done X, Y, and Z under GDPR? If you have a paper trail which clearly documents all the steps that you have taken, that will go a very long way to show that the organization acted in a very reasonable manner. Number three, you want to audit existing supplier arrangements that you may have. And this, I think, it really depends on the type of criticality of the vendor. So if you have a vendor that's collecting a tremendous amount of personal information on your behalf, you want to make sure that you audit them on a regular basis. And there are a couple of ways of doing that. Number one, you can ask them to provide you an annual certification that will comply with GDPR. And there are multiple sources where they can get this information as well. So that's one. You can also have a third party appointed, and this would be paid by the organization, appointed to go in and conduct a GDPR specific audit, identifying any issues or gaps or problems that may occur. And by having that on an annual basis done, if not more frequently, depending on the sensitivity of the data, that will go a very long way to show that the organization has met this requirement. The last point is something that I've touched upon before, but basically have measures in place to prepare records of an organization's collection and processing of activities. And this, quite frankly, could be as simple as having a data mapping exercise done within the organization or a whiteboarding exercise. A lot of organizations have global operations in multiple jurisdictions. In some cases, they're very centralized and it's very clear where the data is going and how it's being treated. In some cases, it's less clear because they are adding on various applications to legacy systems. And so they may be stored within a jurisdiction, they may be consolidated, they may be moved around, it may be in the cloud, a part of it may be on physical servers that the organization controls itself. It can be a variety of things. In that kind of a situation, you want to have some kind of a map that you can pull out and very quickly in a crisis scenario or in the case of an investigation, be able to pull out and say, this is where the data most likely is found, and we can now direct our efforts accordingly. The next bucket of requirements under GDPR relates really to individual rights, and we've heard a lot about this in the media because it is a big concern, especially in Europe, where there have been several seminal cases when it comes to various rights associated, individual rights associated with their data. And I've listed here just a couple, but the right to deletion, or right to be forgotten if you wish, right to be subject to not to be subject to automatic data profiling, right to access, rectification, and portability, which is very similar to what we have in Canada under PIPEDA and our other privacy laws. A right to object to incorrect information and know exactly who to reach out to. That too is very similar to Canada. But the first two are a bit less familiar in Canada and to Canadian organizations, and we'll get into that in just a minute. So in terms of to-do list, you want to review and revise consumer-facing documentation to ensure compliance with GDPR. So think of your, let's say if you have a web application, a website, or a web portal that consumers can interact with, you want to make sure that the language on it is appropriately updated with GDPR compliance specifically required. Second of all, you want to ensure that your internal technology allows you for compliance demonstration to regulators to meet the portability requirements. And this is really important because what typically ends up happening is an organization will collect large volumes of information about a consumer or an individual. What will be less obvious is how is that data, if that individual asked for it back, will be provided to them, in what format, and will it be legible or not. And that's really something that should be discussed beforehand. Number three, review marketing suppression lists that may exist. This is something your marketing teams would be very familiar with, but you want to have those lists updated on a regular basis in terms of who wants to be contacted, when they no longer want to be contacted, how that's going to happen, and if you have multiple vendors who, for example, are sending out your mailing lists for promotional items and so on, how are they going to make sure that they have the most updated list in place as well? That actually touches on the fifth item as well, but I'll skip to the sixth one: ensure that consents have been appropriately obtained and maintained. I know Colin will be touching upon consents in his presentation, but essentially there are specific requirements in terms of how consent can be obtained under the GDPR. It's slightly different than what we have here in Canada, both under our privacy legislation and under CASL, which are two different regimes. But you want to have that thought process in terms of how the consents are going to be obtained and maintained. So just before I get into this slide, I have maybe a couple more to go. And as I'm going through this, if you have any questions, please feel free to use the chat box, which is available through this webinar. And both Colin and I will be happy to answer them towards the end of our presentation if time permits. So moving to enforcement, and this is really where the rubber hits the road and what the GDPR is unique about. In many jurisdictions, you have data protection regulations or laws, but more often than not, they don't have much teeth. And what the GDPR does is quite unique. You have the ability to issue obviously remedial orders and issue fines, but the fines are very significant. In fact, when we talk about them, even from a European standpoint, they're considered to be a very, very significant. And the way they've divided up the enforcement piece, especially on the fine side, is based on the infringement. Is it a serious infringement? Was an organization intentionally avoiding compliance and breaching GDPR, or a bit less so, and were they simply, it was an inadvertence, it was a mistake, it was a first-time offense? And you'll see in both of those instances, the amounts are still quite significant. For serious infringements, the fines can be up to 20 million euros or 4% of global turnover or global revenues. That's a significant amount. So they're not reserving or carving out just your European sales potentially. They're saying anything you make around the world will take a fine or will issue a fine of 4% on that amount. The lesser infringements is about half of that, so 10 million euros and 2% worldwide. So I'll stop there and just maybe spend another couple of minutes before I hand it over to Colin. But you know, the real big question we get is, fine, let's say we've gone through that analysis and we believe we're caught by GDPR. So we're a Canadian organization, we don't have a physical brick and mortar location or establishment in Europe, but based on what you've described to us, that we have data belonging to European data subjects, that we are offering goods or services and we meet the definition outlined in GDPR for that, or that we're monitoring individuals who are European data subjects, and we need to comply with everything that you've mentioned in your previous slides. Well, what do we do and how quickly can we implement it, and what is expected of us from the European regulators? And here what we've done is in about 9 different very simple steps. Some of them are a bit more complex than others, but 9 broad category of steps that you can implement to see where you are on the spectrum and what needs to be done. So firstly, you want to do a mapping exercise, which is basically formulating a plan. Are you caught by GDPR, yes or no? Do you believe you're collecting information that belongs to your European data subjects? And if so, how are you going to make sure that you're going to be compliant with GDPR? You want to take some time and appoint a data protection officer. So this is the individual who's going to be responsible under GDPR for its compliance. You want to map out all the personal data that you're collecting from European data subjects. You want to know where it's located, how it's collected, and in what condition it's stored. Is it being transferred from one cloud provider to another, or is it stored on physical servers in Europe, outside of Europe? Those are questions you want to go through. You want to look at the impact. So if there was a breach, for example, what would that do to the organization? Would you be able to respond, and how quickly? Do you have the appropriate insurance in place, and so on? And then you want to start taking proactive steps. You want to address the risks, and that will be a specific requirement. And here's the challenge. GDPR, for those organizations that are based in Europe, people have been working on GDPR compliance for months, if not well over a year when the legislation was passed. And they're having trouble and challenges making sure that they're going to be compliant by the May 2018 timeline. So what we recommend clients to do is really set out a priority list. You may have, let's just pick a number, 10 different items you need to comply with between now and the implementation of the regulation. Between now and then, you can realistically, based on resources, on cost, and on time, you can only implement legitimately 5 of them. You should start with those 5 right now. And the reason I say start with the 5 is if you were to have a breach, or if the regulator from Europe did come calling, you can show that you had a roadmap in place, that you had steps that you were taking, and that will go a very long way, quite frankly, be able to put the regulator at ease, provide them some kind of assurance that you're dealing with the issue, you're not just ignoring it, and that you're going forward with a plan to implement full compliance. You want to update your data governance program. You want to implement some new compliance systems if that's needed. That's really for specific items that we talked about a bit earlier. And you want to review your supply chain contracts, which I talked about as well. But essentially what you want to do is make sure that everything that you have in Canada, and assuming you've thought about supply chain and your protocols and policies, and you've done the employee training as well, you want to basically take that base, which is your benchmark, and build on it by adding the GDPR requirements. So you're actually ending up with a much more robust standard. And this is the example I give to a lot of clients, especially those who are located in the US. In the United States, you have something like 40 some odd or 47 odd state regulators that have specific breach notification requirements. And those 47 state requirements vary from one state to the other.
So good evening, good afternoon from the UK. Welcome to the webinar. While the slides are going. So my name is Colin McClure. I'm from Appnovation, and I'm a solutions architect. And I'll be talking about touching on 3 areas of the EU GDPR, basically. So 1 being consent, 2 being data access, erasure, and deletion, or more commonly known as the right to be forgotten. And lastly, then going into things like data recovery, and as it does affect that as well. So skipping over the first slide, as Imran already did an introduction for Appnovation kindly, so I'll move on to my first realm. So consent. So consent is a big area, and to be honest, most of these areas could do with a webinar by themselves due to the complexity of the GDPR. However, what I'm trying to do today is to touch on the high-level points that one should be aware of when it comes to this regulation. So consent. Consent, the GDPR requires the data subject to signal an agreement by a statement or a clear affirmative action. So there's a need for explicit consent. So gone are the days of coming to a website with a registration form, filling in your details and clicking submit. There might be a sort of hidden paragraph or a small bit of text on the registration form that signifies that by registration you are agreeing to our terms and conditions. That is a direct, can no longer happen under the GDPR. The GDPR also introduces restrictions on the ability of children to consent to data processing without parental authorization, so where children are typically below the age of 16. And a request for consent to data processing must be clearly distinguishable from any other matters in a written document. It must be provided in an intelligible and easily accessible form using clear and plain language. So in other words, all data that a website or application makes use of must be transparent on what the usage of that data is, effectively. And I'll go into more detail on this in the coming slides with regards to consent. One of the other areas is that you may already have consent. So people have registered applications, have gathered consent. One will need to re-audit that and make sure that those consents are in fact or meet the standards of the GDPR. And if not, that consent will need to be refreshed. And of course that in itself poses problems and technical issues. So how do we do consent? So consent request is separated or unbundled. So in other words, every form of consent must now be unbundled. If I am agreeing for you to use my data to email me certain information or send me promotions or inform me about other partners that you work with via your website, or you've gathered data that you wish to use for marketing, then the consent for each one of those, let's say, categories of data usage, I have to consent to. So it's extremely important to unbundle. So we can no longer have those simple checkboxes which say I agree to the terms and conditions of this website, for example. You can no longer have active opt-ins. So the notion of potentially subscriptions going to the subscription page and the checkbox is automatically checked on your behalf. That can no longer occur because it needs to be a direct, and consentment has to be almost a double opt-in in order to consent. The other side of this is also that you have to name the organizations and any third parties. So if I'm collecting data via my website and I'm exposing that data to other third parties who may be using that data to market to me, for instance, then I need to name those parties. And as per the consent unbundling, you are then having to actually consent to having that organization or parties use the data in a specific way. I'll provide some more examples in the next coming slides. You also have to be upfront about consent withdrawal and how to do this at any time. So as easy it is to consent, it must be to revoke your consent. So no longer can you provide a telephone number, or you have to jump through 10 levels or hoops to actually get yourself removed from the database, let's say, or no longer contacted. It now must be easy to consent, and therefore remove consent as well. Clear records, so keep an evidence of who provided consent, when the consent was provided, and how the consent was provided, and what the individual was told. So now it becomes, having records of consent, date down timestamps, for instance, within a table, to show when the consent was, and also confirmation that the consent was actually gathered from the data subject in question. And I touched on this with regards to the double opt-in. And by double opt-in, I mean you may tick a box on a form, you may submit that form, and an email is also sent to the email address provided, and they have to click within a link within the email body to actually confirm that consent. So here's a couple of examples of consent request separations. These are live examples that I hunted down on the internet as they exist today. So here we have an example of a terms and conditions page. where one is doing a registration, and clearly there's a separation between agreeing to the terms and conditions and joining the mail list. So all too often these days that's been bundled together into a single checkbox, and you can't disagree to being on the mailing list and agree to the terms. So a good example of unbundling. Granularity of consent. So here we've got the notion of being able to decide on our communication preferences, whether we wish to be SMS'd, or do we wish to receive emails, or do we simply only want free samples. So again, a good example of the granularity that has to now happen. Naming third parties. So Waitrose is a local supermarket here in the United Kingdom, very large, probably the size of Walmart and those kind of Canadian companies. They have to here name the actual partners. So in this case, Waitrose partners with John Lewis and also John Lewis Financial Services. And they've had to provide a checkbox here to say that I am willing to consent that my data can be shared with these additional partners or not. So what are the technical implications of consent? So most websites are CMS based, and the notion of a GDPR compliant CMS has risen. So there are CMSs touting that they are GDPR compliant, and they are using various terms to support that notion. But the main thing to realize here is the ability or agility of your platform will help to aid in GDPR compliance, but is by no means the silver bullet. So considering the idea of unbundling, history of content, so the ability to confirm 100% that data subject performed the consent, for instance, I've touched on this as being the double opt-in comes into play. A lot of this is going to require involvement from development and technical people. And you also need to ensure content, the consent is obtained prior to cookies being placed on their machines. So there are various technical implications which come out of the GDPR. So how long does valid consent last? So the important thing here is the sort of guidelines are the 18 months to 2 years. So technically there is no time limit on consent, but it does depend on circumstances of the request for consent and the general nature of the data processing. The consensus is that there's probably a need to refresh consent every 2 years. So moving on to data access, deletion and erasure. This is a very hotly debated topic. It revolves around the right to be forgotten. It's been debated all over the internet, in YouTube videos and forums and so forth. But essentially, the idea behind this is that a data subject has the right to obtain, if we look at data access first, that basically I can request all of the data that you are holding on me, for what purpose that you're using that data, and to whom other entities you've provided my data, the period of time during which the personal data is stored, and the right to lodge a complaint regarding the use of the data and the source of the personal data. And through this I can also submit and amend my data as well if it's incorrect. But essentially the data subject has a considerable amount of power in terms of their data. So any company or public authority who collects personal data has an obligation to give data subjects full access to their data for no reason other than individual making the request. So you will hear of terms like this data subject data request, where you can submit to have your data supplied, and this also means and improves the idea of portability. So in other words, I can request my data and give that data to a competitor, for instance. So under GDPR, a controller must on request provide data subjects with an export of all their personal data in a machine readable format so that the data can be transferred from one data controller to another. So again, the technical implications of all of this at a high level is that, for instance, a CMS is going to have to help with the right to be forgotten, but it still needs to abide by local legislation as well. So it might be that certain data has to be maintained for a legal standpoint and other data removed. This also affects other areas like data backups, where that data is stored, and updates as well. So the data could be spread all over an organization, and it's the idea of becoming a single record about that user is most of the technical challenge. When we talk about CMS as well, they're going to have to allow for the retention policies of data and the refresh of that data, maintain all logs for notifications and the consents. So we need to have all those records and an ability to export or report on those. So there's definitely potential development to be carried out to provide reporting capabilities and exports. Not all CMSs or systems provide direct report or an export that's in a nice format or a CSV format that can be exported out and given to the user or data subject to move into other systems. So there's definitely going to be implications. And changing systems, as we know in the world of IT, is never a straightforward decision, and time penalties are incurred when one does that. So data access extends to DR as well, so which is coming up in the next section. So what are the best practices? So where possible, organizations should be able to provide remote access to a secure self-service system, which will provide the individual with direct access to his or her information. So typically the idea of a self-service portal where you can see your data, you can amend it, is going to go a long way to supporting the notion of the GDPR and data access. It's not going to be appropriate for all organizations, but there are some sectors where this may work very well indeed. Prioritization of carrying out data protection audits is, as Imran has already mentioned, that's going to be the clear way through and the clear path from a technical standpoint is identifying all of that personal information, where is it currently, how is it stored, and getting a unified view of that prior to May 2018. So in terms of business continuity and disaster recovery, a good example of this recently is British Airways has apologized for the total chaos due to system failure. So very recently, this was all over the news, British Airways being a very famous airline, they suffered an extreme, it was almost 2 days of outages. Basically the entire system fell over. So how does it relate to DR? So Article 32 from the GDPR states in 2 of the clauses that the ability to ensure the ongoing confidentiality, integrity, availability, and resilience of processing systems and services. So Imran touched on this regarding encryption, encrypting the data. So we are talking here again about ensuring the data is protected as physically and technically possible. But we're also now touching on the resilience. So the systems must be resilient, must have data backups, must have DR plans, and so forth. The second clause sort of now hints to the idea of the ability to restore the availability and access to personal data in a timely manner in the event of a physical or technical incident. So there isn't exactly a definition here. Timely suggests, what is that period? But I'm guessing, and there is going to be more consultation on this, that timely is going to mean a fairly quickly time, given that a lot of the other time frames are tight, such as a breach within 72 hours. So technical implications. Many large businesses rely on backup tapes still today as a fixed form of storage. We do have SSD backups and backups to disk. However, the length of time the tapes are required to restore data may be prohibitive. So talking back to the timely clause C on the previous slide. So you may be in breach of the compliance of the GDPR for that. There's also a need to have suitable RTO and RPO in place. So having the objectives of how quickly you can get parts of the system back in place. Essentially, is the need to ensure that DR plans are fully tested and working as expected. And a very important point here is that any DR partners or suppliers will also need to be GDPR compliant. As Imran has said, auditing your current agreements with other suppliers, it will certainly apply with regards to the IT suppliers as well, who perhaps are doing your DR and managing the servers and so forth. They will also need to be considered because they will be classed as data processors as they're holding data. So a final thought. So British Airways showed recently how badly a large organization can get DR wrong, and under GDPR regulations, that could result in a significant fine. So as we've seen, some of the fines here is up to 4% of global revenue. That could be a very scary amount of money, but as Imran has also mentioned, this could be and should be hopefully a sliding scale. Financial penalties aside, the long-term scarring for brand reputation should not be underestimated. So in summary, compliance with the EU GDPR is not only an IT effort, it also revolves around, it's not just privacy and a legal effort, and it's not something that tools or technology can address. And we'll often see statements around the internet and YouTube videos and so forth. The GDPR is actually a full stack implementation. So technology can help, but it ripples through the entire organization in terms of compliance. And it requires considerable effort, as we are finding. There are some useful links. The slides will be sent around, so these links will be clickable. They're just some direct links to some of the clauses that I've pulled out into the slides, so you can have those at your leisure. And thank you for listening and participation, and happy to answer any questions. Feel free to email me.
That's great. Thanks, Colin. It's Imran, and I also wanted to maybe add a couple of quick comments and also answer one of the questions that came through our chat box. So a couple of points which I had mentioned before as well that may be helpful. Canadian organizations that are compliant with PIPEDA or equivalent or substantially similar privacy legislation in their jurisdiction, that's typically Quebec, Alberta, and British Columbia, shouldn't just rely on that compliance to meet GDPR requirements. And I hope through the presentation both Colin and I provided, it was clear that there's some additional requirements under GDPR that are not covered in Canadian privacy law. So that's the first point. The second point is, each organization needs to do their own assessment. It's not where only when you get a request from the regulator or if somebody comes knocking on your door saying, are you compliant, that you should be conducting the GDPR assessment at that point. In fact, as GDPR got adopted, a lot of clients came to us and asked, we're not sure whether this applies, and we work with them both on the legal and on the technical side, trying to figure out whether they were caught under GDPR, because it's a pretty clear test as to whether you are or not caught under GDPR. And that document serves them that if somebody does knock on their door at some point, and let's say the company or the organization made the determination that they were not caught by GDPR, they can provide that document and that assessment to the regulator. And it gives them some comfort that they're not just waiting for somebody to knock on the door and hope that they're compliant or not compliant or not applicable to be compliant, but that they actually have put some thought process and they have something they can hang their hat on at the end of the day. So those were the 2 points I just wanted to make, and I felt Colin's presentation was actually very helpful because it gives you the technical piece. I can give you the overview in terms of the requirements under GDPR, but what does that look like? And I actually found those screenshots very helpful. One of the questions that came through the chat box was, we're talking about a European regulation that applies to Canadian organizations. What is the ability for that European regulator to enforce something against us? And that's a really good question. Quite frankly, that's the $1 million question, or in some cases, the $20 million question. And it's a bit difficult to answer in the following sense. Now, there's certainly no MLAS, no mutual lateral assistance treaty between the data protection regulator in Europe and the Canadian regulators. They have the one-off transfer of information or collaborating on an investigation from time to time, but there's nothing formalized that will make it such that a European investigation can then be enforced through our Canadian privacy regulator. However, as I mentioned in my earlier slides, you do have the European regulator with the ability to go to the court in Europe and get a judgment against a company they feel was not compliant with GDPR, either because they didn't respond to the requests, or that the response they got were deficient, or that they concluded at the end of their assessment that they were actually GDPR non-compliant and it would have applied to them. In that case, they can take that court decision and come to Canada for enforcement. And for that, we certainly do have agreements between European jurisdiction and Canadian jurisdiction to have the enforceability of a court decision imposed in either jurisdiction. So my point in that is, maybe not regulatory action directly, but if a court decision is issued against an organization in Europe, it can certainly be enforced in Canada. And in terms of how aggressively the European regulators will enforce GDPR vis-a-vis non-European entities, that's a question mark. But that was the same question we had with respect to Castle. We've had the same question about the Defense Trade Secrets Act, and we're now seeing, especially on the US side, no hesitation to be able to draw Canadian or other entities into the US legal system where it suits their needs. And so think of large multinationals in Canada that have information about European data subjects. It would be very easy for a European regulator, if they see a trend, to go after one or two to make a demonstration. We certainly have seen that under the Castle model, where they will go after a big fish, quote unquote, so they can make a point in terms of enforcement seriousness. Colin, I don't know if you have any additional thoughts on that.
Answered.
Great. So I see we're hitting 2 o'clock, and maybe this would be a good opportunity to wrap up. A couple of closing comments. Hope you found the webinar helpful. Clearly there's a lot of material in here, so what we will be doing is sending out an email to all of the attendees and those who couldn't stay on for the entire webinar. By email, we'll be supplying them with a recording of the session. We'll be providing them a copy of our PowerPoint decks, as well as an article that we have put out in terms of GDPR and its relevance to Canadian businesses. And in the PowerPoint decks, you should have Colin and my contact information, and happy to have a conversation, or if you have any questions that come up afterwards to see whether this applies to you or not, we would be delighted to assist. And with that, I'd like to thank you all for spending an hour of your time with us, and hopefully this was helpful.